Kia ora koutou, good afternoon everybody. Over the last few years we have seen an increase in retail crime, including things like ram raid offending and smash and grabs. This has been of significant concern to the community and it's been of significant concern to the government. We acknowledge that many of the people involved in this type of offending are young people, including children as young as 12 and 13. We have been failing as a country to deal with the youth offending that we are now seeing, and we need to do more. We have also been failing the victims of these offences, and we need to do more. I acknowledge that for many of the victims of this offending it has been a traumatising experience, and there are too many people now afraid to go to work or afraid to even live in their homes if the homes are attached to their work because of this type of offending. As I said on Monday, we acknowledge that concern and we acknowledge that there is more that we need to do. The government has been taking serious action over the last year to address this type of offending, recognising that many of the people involved in the offending are children and young people. We've been conscious to take a different approach, one that seeks to break the cycle of offending and set up opportunities for a life outside of crime for these kids. Last year we put in place a range of programs that aim to better re-engage these children who have been offending in education or training or employment and to better connect them to their local communities. So far those programs have produced some significant successes. They are working for around 3/4 of the young people who have been referred to them. However, that does leave around 1/4 of repeat offenders who are creating and perpetuating the problem. On Monday, I announced a range of measures to add to our toolkit, such as requiring young offenders to attend education programs or do community activities, adding things like posting ram raid offending online as an aggravating factor at sentencing. Our work here is designed to create a continuum of interventions so that we can escalate our response proportionate to the level of reoffending. This isn't about unnecessarily locking up young people or escalating them prematurely when a lower level intervention can get them back on the straight and narrow. As I indicated, around 3/4 of young offenders who have been referred to our more intensive programs, our earlier intervention programs, have had successful outcomes for that. But we clearly need to do more for the 1/4 who are continuing to go on and reoffend. Today I'm announcing the final piece of the puzzle that we have been working on that targets the worst repeat offenders, where the current interventions simply haven't been working. We will be introducing a new criminal offence for ram raids that carrying a maximum 10-year sentence, the same as for burglary. It reflects the serious nature of the offence, but importantly for this offence, we will also be amending the Oranga Tamariki Act so that a 12 or a 13-year-old who commits a ram raid and is charged with the ram raid offence can be escalated to the youth court. That will unlock a range of additional interventions that are not currently available for those 12 and 13-year-olds. That recognises that for a small group of young offenders, we need to do more to break the cycle. The change that we're making recognises the magnitude and the impact that ram raids are having in our communities, especially the impact that those repeat offenders are having. It also sends a clear message to young offenders that there are consequences for their actions. Having said that, I want to repeat, this isn't about sending children to prison. The Oranga Tamariki legislation that was put in place under the previous national government makes it very clear that when children offend, the system must do everything possible to avoid those children being trapped into a lifetime of crime, ending up in and out of our courts and in and out of our prison system. Our goal here is to break that cycle, which is why we're focused on interventions that work. The new offence will not be the first port of call for first-time ram raiders. This is for the worst repeat offenders, recognising that those earlier interventions simply haven't been working for that group. We must do everything that we can to give these kids a chance to get their lives back on the straight and narrow. But where the offending continues, there needs to be accountability, and there needs to be a higher level of escalation. That's what the law change that we are putting on the table will do. I'll hand over to Minister Allan for some more details, and then we will open up for questions.
Thank you, Prime Minister. I'd like to start by laying out the gaps that have been identified within the youth justice system since we've seen a rise in ram raiding offending. And then I'll talk through the new offence we've announced today that will address these gaps. In the absence of a specific ram raid offence, alleged offenders are generally charged with burglary, which carries a maximum sentence of 10 years imprisonment. We've repeatedly heard concerns that this offence does not adequately recognise the seriousness and the destructiveness of ram raids and the considerable harm it causes victims. Additionally, we've heard concerns that there is a gap in the system in how we respond to children under 14 whose offending behaviour is serious but does not meet either the threshold for the youth court or care and protection interventions. As it stands, ram raid offending by children and young people who are defined in the justice system as people aged 10 to 17 is addressed by the Oranga Tamariki Act. While young people are able to be charged with most offences in the youth court, most children under 14 who cannot be charged are dealt with outside of the formal youth justice system through police-led alternative action or through care and protection processes. There are a few instances where more serious offences by children can be considered by the youth court, and for example, charges of murder and manslaughter. But in addition, children aged 12 or 13 may be charged in the youth court where an offence carrying a maximum term of imprisonment of at least 14 years, or where they are defined as a previous offender. This has placed limits on the responses to children aged 12 or 13 and how we can manage their risk of reoffending in the best ways possible, in particular in the immediate period following a ram raid. Without police having the jurisdiction to charge a child of this age in the youth court for a ram raid offence, there are fewer interventions available that could stop repeat offending. We know there are about 153 children that have been involved in ram raids since January of last year. As a result of gaps in the current system, children and young people do not always receive responses with the right level of immediacy, intensity, or duration to address their needs and the underlying factors that contribute to offending. So if I turn to the offence specifically, the construction of the offence would mean that it would apply to passengers in the vehicle, not just a driver, as long as those passengers also enter the building with an intention to commit the offence. So if a younger sibling has tagged along and didn't know what was occurring, this offence would not apply. A passenger who actively participates in that ram raid will be captured. The requirement to prove intent to commit an offence once inside the building is consistent with burglary and provides an important safeguard for children who may get caught up in a ram raid without any criminal intention of their own. While the new ram raid offence will apply to everyone, regardless of age, the most significant impact will be on those 12 and 13-year-olds. The change we are making to the Oranga Tamariki Act to make 12 and 13-year-olds who commit this offence come before the youth court will enable a much wider range of system responses for this age group, including bail conditions and curfews. At the most severe, this will mean a supervision with residence order. This involves a child being placed into the custody of Oranga Tamariki in a secure youth justice facility for a period not extending 6 months. But as the Prime Minister has said, let's be clear, the maximum period of imprisonment will really, if at all, be imposed on a young person aged 15 or over, and it remains unavailable in respect of children. New Zealand's system for responding to offending by children and young people is geared away from punitive responses. The Oranga Tamariki Act provides for that. Having the options available will not mean that children are escalated through the system, as the Oranga Tamariki Act provides a strong direction that taking the least restrictive action and seeking alternatives to prosecution is the preferred route. While this has been effective in decreasing youth offending rates overall, as the Prime Minister has observed, there is still a cohort that we are not reaching. So we need to consider stronger measures and enable decision makers to have a broader suite of tools, particularly offending behaviour where it is serious and persistent. These additional response options, they will not be mandatory and will continue to be subject to police discretion, prosecutorial discretion, and of course judicial independence. Thank you.
Thank you very much. Happy to open up for questions.
Prime Minister, you've just admitted that you've been failing in how you've been dealing with youth offending. Why now? And what do you say to all those people who for so long have been saying you have not been doing enough and didn't feel listened to by you?
We have been doing more and more and more. Now, if the intervention programs that we put in place last year had been 100% successful, we wouldn't be having this conversation. They've worked for about 75% of the young offenders involved. So it was the right thing to do to focus on earlier intervention to break the cycle of offending. But we recognise that we still haven't got there for around a quarter of these kids. And so more is required. That's what we're doing this week, and that's what we've been working on for the last few months. Because, you know, my first preference is always to treat these children as children who have lost their way, get them back onto the straight and narrow, and avoid them ending up locked up in the criminal justice system. We've done that far too much in the past. Or we've left young people offending and waited until they're old enough to do something about it. We've got to do more. We can't just sit back and wait until these kids are old enough to actually escalate the response. So what we're doing, what we've been looking at doing is saying, okay, which parts of the response can we bring in for those kids who are younger to stop them ending up trapped in that cycle? I don't want these kids to spend a lifetime in and out of jail. I think that would be a failing of all of us as a community. I think we can do better at turning these kids' lives around, breaking the cycle, and actually giving them a future to look forward to.
I admit that you're failing now.
Because it's clear for the victims of this offending that what we've been doing hasn't been working. This is not just a failing of this government. This is a societal failing that is built up over a long period of time. We have to do something about it.
So just on that, you do admit that it was a failing by your government, and you were the police minister for a lot of this time. Was this a failing by you as well?
No, as I've indicated, you're misinterpreting the words that I've said. I've said that what we've been doing as a society for these kids has been failing. What we've been doing in terms of our response has been failing, but we have been escalating that response. We introduced the turnaround programs, the rapid intervention programs, because we wanted to do more. And that's been successful, but it still hasn't reached the most serious and persistent offenders, so we have to keep doing more.
So society is failing, but the government's not failing on this issue.
It's a ridiculous question.
When you were police minister, you asked about forming a new ram raid offence code, and I seem to recall you were told that it either wasn't needed and or it would create too much of a burden on police to try and put that in. So what's changed?
A new ram raid offence code without a new offence clearly wouldn't work for the police. So police's coding works based on the offence that someone is charged with. So with a new offence, yes, we will have the police will be coding these offences in some cases where that's what people are charged with against that.
I think probably it's important just to acknowledge there as well that having the ability to be able to prosecute 12 and 13-year-olds in the youth court jurisdiction is certainly something that the police have been seeking. And it is, as the Prime Minister rightly just said then, it's for that 25% of those younger people that we just haven't been able to crack through with the tiered approach of the prevention measures and otherwise. But this is certainly something that the police have been seeking.
I mean, we've heard for the better part of 18 months that there have been kids under that 14 age group that haven't been held accountable to what the people in the community and store owners, business owners would like. So why has it taken this long?
As I've indicated at the beginning, our first preference is always to break the cycle for these kids and to not end up having to escalate the level of, consequence or the level of retribution or the level of escalation that we put in place, recognising that for 3/4 of the kids we've managed to find other alternatives, but there is a persistent quarter where we still need to do more.
Prime Minister.
When are these?
Prime Minister or Minister, just so under this new regime, can you talk us through what will happen to one of these young people the first time they do a ram raid, and then what would happen the second time they do a ram raid?
Yeah, absolutely. So let's say we've got a 12-year-old and she goes out and commits her first ram raid offence. The options available are, first and foremost, they can put in an intensive kind of intervention, and that's what we've seen. Programs like you'll hear Kotahi Te Whakaaro, for example, where they go into an environment and really work through, arrange, make sure that there's support, etc. We've also, as a consequence of Monday and decisions made then, and what we're announcing as well today, an intensive intervention. We've set aside resource to be able to essentially pair up a social workers, drug and alcohol facility, whatever's required for that young person to essentially be there on hand 24/7 for that young 12-year-old. Now, where those intervention measures aren't working as society might expect, that's when we've created two alternative pathways. One is the announcement that we made yesterday that sits within that care and protection regime. I guess you could say that there is a broader scope to be able to deal with things through family court group conferences within a truncated time frame, victims engaged in that process, etc. But we also recognise that we need to have further tools in the toolkit. The Youth Court provides a range of orders that are available, programs that can be available, that police and others simply can't access without having that pathway into the Youth Court. So let's say this young 12-year-old has committed multiple offences. They may have tried with some of these earlier intervention programs. It's not working as we would expect. At this point, the police and prosecution, they may decide to prosecute directly, to take that young person into the youth court. Once you open up that environment, that's when things like, you have the Bail Act provisions start to apply. So you can have curfews, non-association orders, parenting orders that apply directly to the parents of those children. But there's a lot more tools in the tool belt for decision makers to be able to utilise.
I think one of the things that we acknowledge in the spectrum of interventions that we've got in place now is that young people will come to this situation through a variety of different pathways. For example, you could have a younger sibling sitting in the back of the car who actually is effectively just being dragged along in the offending. We don't want to find them, facing a very stiff and severe intervention first up. We actually think that there's probably an opportunity for us to turn that kid's life around. On the other hand, if the kid who's driving the car has been doing it 10 times before, then the intervention may need to be a stronger one.
I guess for the public, the question is it the case that the stiffest thing will basically, the potential custodial sentence or whatever will apply once all the other options are exhausted, or is it more a case of, hang on, if you've done 3 ram raids, actually we're going to throw the book at you? How are you looking at that?
The discretion really will be, as we enable ordinarily, to the police and to the prosecutors and then ultimately the judiciary. So what we've enabled, it would be, I couldn't say, first offence, off you go, but the police will have that information before them as to what the best route is. So it's about providing those additional tools.
On the 25% that you've talked about, can you just dig a little bit deeper as to what it is that you think are the underlying causes for that 25%? Because I guess what I'm asking is has this cohort existed over decades and decades and just been doing different serious offending, or is this a new group of young offenders? And if it is, what is the drivers behind that?
I'm sure we both have a view on that, but I'll have the first crack at it. I mean, it's difficult to draw hard and fast conclusions because, of course, people grow up. So the cohort we're dealing with now is a different cohort to the one we might have been dealing with 10 years ago. So it's difficult to kind of say, would these kids have just been doing different offending had those kids been alive 10 years ago? Difficult to draw those types of conclusions. But clearly things like ram raids, there have always been ram raids. I remember them when I was a kid. People used to drive cars into ATM machines. This isn't something that has just suddenly started to happen. But we're seeing more of it, and we're seeing more young people involved in it. It's very visible, and it is creating a huge amount of concern within the community. So for those small business owners who are lying in bed at night, living, in some cases above their business or behind their business, worried that it's going to happen to them, I absolutely acknowledge this is a very real concern, and they want to see us doing more about that. I've been, in the time that I have been engaged in this over the last year since I became Minister of Police and Minister of Prime Minister, I've met with many of the victims and I've talked to them about that. And we've been continuing to work on options to address this concern. So this isn't something that we're just doing now. This is something that we've been working on for some time. The patterns are difficult because, as I said, kids grow up and kids, and society has changed a lot over the 10-year period too. But I'll let the Minister have a crack at it too.
Oh, look, no, Prime Minister, I absolutely agree. And, we'll all have our own recollections within our own growing up periods of time where there was different offences that were the flavour of the month, the year. And, that's certainly the feedback that we get from police as well. Right now, yes, it's ram raiding. Not that long ago, it was going through the rooftops of shops. They lifted up the ceilings, and that was the issue that needed to be targeted. But why we're introducing, I think, particular targeted remedies right now is because we have seen, since January last year, by and large, such a volume that has really caused significant, it's penetrating through to all parts of our communities.
I'm just trying to get beyond that a little bit, and when these young offenders are sitting down with whoever it might be, a social worker, police, etc., what is it that they are saying is happening at home, happening at school, happening in the community? What are the actual drivers leading to this behaviour that you are being told that you're now designing specific legislation, offences and stuff around to deal with? So what is the issue?
The cycle doesn't just start with the child, and the evidence base of that's pretty clear. A lot of these kids, the vast majority of them, would have a parent or an adult in the house that they are living who is also engaged in the criminal justice system. So when I talk about breaking the cycle, it's not just breaking the cycle for these kids. These kids are coming from a life where that is a dominant theme in the way that they are living. And so we need to be doing more to break that, to provide more support, more intervention.
There's an interesting, police provided this the other day, but it's something around about 80% of all children and young people that are committing ram raiding offences have had at least one family violence call out to their homes. Approximately, I think it's almost as high as 100% of those that are committing more than 5 ram raid offences have had family violence call-outs to their home. So we know that there is a lot happening within those homes, and I think that this has been part of the consternation that police have is that, well, it's not always the best and most ideal circumstance to take that young person or that child back to their home environment. So when we look at these provisions, and they are an expansion of what police can do, I think we've really been trying to focus on what's in the best interest in these circumstances for those young people where those supports simply aren't in the home.
Just last thing very quickly, the cohort we're talking about, is it bigger than in previous years/decades, or are you talking about a similar group of serious youth offenders over the years?
When we both took over our portfolios at a similar time when I became the Minister of Police, and jointly we went through a program of work where we got the relevant agencies together and we said, let's talk about the kids who are the most prolific, the serious repeat offenders, and we asked them to literally go through and itemise them anonymously so that we had an idea of who these kids are and what they're engaged with. And it actually got down, I think we got down to a list that was like just under 100, and then when you did a bit more searching, it actually got down to a smaller group than that. So if you looked at the target hotspots, for example, where it was happening all of the time. And that's where the intensive intervention programs that we put in place started, because we were starting with this cohort. We knew who they were engaged in this serious and repeat offending. By doing that, by targeting their siblings and other kids who were on the periphery of that core group, as I've said, we managed to find programs that for about 3/4 of those kids were making a real difference, but there was still that quarter that was actually quite hard to reach. So this program of work, and the point that, getting to this announcement today isn't just something that we've started to do in the last few months. This has been something that we've been working on for over a year now, building that kind of evidence base, identifying what are the sorts of things that are actually going to break the cycle for these kids. And this is the final piece in that puzzle.
The question was, is it bigger? Are you dealing with a larger number of serious young offenders now than you would have been, say, a decade or 2 decades ago?
Well, we don't have evidence that says that.
So can I just get a handle on the numbers here? So I think earlier on you said 150 kids, and then we're talking about 25% of those, right? So we're talking about a few dozen.
Well, obviously, there's been more since then, so there are more kids who have ended up being sucked into that since then. So I don't have an absolute number right now, but we're talking hundreds. We're not talking thousands.
Do you know how many?
Just to come back on that, look, 153 since January last year, children. So that's in that under 14 cohort. We've done a little bit of modelling there to see what kind of numbers we could anticipate going down this particular route, the backstop route, if you will. It's in excess of 20, under 50. Don't expect that there's large numbers. If you heard the Prime Minister just prior, when we originally started to look at this work, the cohort of significant offenders was around about 100-ish. So it's in that quarter of those numbers that we expect will be going down this route.
Given these early intervention programs have been so successful at hitting 75% of the ram raiders, could you not ramp those up or tweak those more to try and catch the rest rather than coming in with the retribution?
Absolutely, and I think that's certainly what we're doing. Part of the announcements that we're making today is that we are funding and providing intensive interventions. So as opposed to that young person going along to a program where we've seen that 77% success rate, so to speak. Well, we're also giving the ability to be able to provide just basically one-on-one intensive intervention, but we also acknowledge that that won't be suitable in all circumstances, and so therefore we are providing this avenue, which doesn't just provide punitive measures. That's not the purpose of the youth justice system. It's a part of it, but it also provides a whole range of other measures, programs, orders that decision makers can utilise as well.
So the way it's put it is, if you think about it as a continuum, first-time offender, only peripherally involved, police intervention could be relatively light at the beginning because it may well be that picking them up, taking them home, them getting a good telling off from their parents may well be enough for that young person. If a more serious intervention is required, then there's already existing provisions that police have used successfully for some of these kids previously. Then you've got escalation to the family court, and we've added new tools in for the family court. Then ultimately, you've got this escalation to the youth court, and we're providing some new tools in there. So you don't go from first-time offence suddenly to the very extreme end of that spectrum. Based on the proportionality, based on all of the factors involved in the offending, there'll be discretion, there'll be judgments made all the way along about what the most appropriate intervention is.
For those tamariki who are repeat offenders then who do end up in oranga tamariki, how safe is it for them given that OT also has issues? We've got a Bush inquiry at the moment, so you're taking them from one bad situation to another.
You can have a go.
Yeah, look, I think just to be really mindful that it's not necessarily that those children do end up in the care and or within the oranga tamariki system. That is, as we know, it's the most punitive measure available to those decision makers. But there's also that broader range of tools available. So, for example, a couple that I think are pretty useful, things around like monitoring, curfews, non-association orders. You've got, things like drug and alcohol orders that can apply directly to those tamariki. We've really tried to balance this so that it's not just a coercive power and we're chucking these kids into jail forever, but it is actually in some circumstances where they can't access or haven't been able to access the right supports required, what interventions therefore fall on the state to be able to make those interventions for them.
So when you say monitoring, are you saying putting ankle bracelets on 12-year-olds?
Well, that is a part of that's already something that can apply to children in particular circumstances where they've been charged with a particular type of offending. So that already exists. For those that are charged within that youth court jurisdiction, those types of things become optionality for decision makers where they consider that they're appropriate.
You were saying that a large proportion of these kids committing ram raids are coming from homes where family members have also been committing criminal acts. Is there not a risk of sending them back into those environments? Keeping them under curfews in those kinds of places could expose them to further harm.
I think that's a really important question because it talks to the multiplicity of the environments that decision makers currently have to weigh. Now, what we've heard from them very clearly is that they don't have all the tools that they need. If it is to take somebody out of that environment, they don't necessarily have the tools that they need. Or if it's to keep them in that environment because it is the right one, they don't necessarily have the tools that they need. What we've done today is probably the fourth tier of measures that really provides a full range of options now, right from being able to put people in different locations or to be able to monitor within homes, plus a whole range of other orders. But we've given that optionality to decision makers as a consequence of the announcements made today.
Just to get that straight, you're creating a criminal offence for 12-year-olds which could include a punishment of an ankle bracelet.
Well, that's already so that is already something that's available to those that are charged in the youth court jurisdiction.
That's 40-year-olds, isn't it?
No, so for those that are charged with particular types of offending, that's already an option that's available.
Like murder and manslaughter, though.
Murder and manslaughter, also anything that carries a maximum sentence of 14 years. So if I take the example of aggravated burglary, which is currently something that a number of ram raiders are charged with, where they have a weapon on them, they're sitting in the car, have a weapon, they go and smash a window, you can be charged with aggravated burglary. So that ability to charge particular children is already available to
a lot of criticism from Labor towards ACT on a similar policy there. So
where that's the backstop, I think that would be where that is the primary option and the backstop. I think that would really be an unjust way of looking at the way that we tackle these issues. What we are doing, though, is making sure that those people that need to make the decisions have that full suite of options available.
I mean, when are these changes going to come into effect?
Well, we will be introducing the bill within the next couple of weeks, but we do want to go through a select committee process, so that will take some time.
If you've been working on this for some time, over a year, why have you left it right up until the election when it's not possible to pass it?
Well, I can tell you that when we first started having conversations about this a year ago, as I've indicated, we both were relatively new into our roles, Kiri as Minister of Justice and me as the then Minister of Police. We started looking at the range of options, including legislative change. This has taken some time to work through as to how we can best target the legislative change to meet that criteria that we set, which is that this is about the most persistent, serious, repeat offenders. We don't want this to become the default for all kids who find themselves getting into trouble potentially for the first time. And so we had to work through a range of options. There's complexity, and there were a lot of discussions over the last little while about how best to do that. Was that, for example, amending existing criteria around an aggravated burglary, for example, rather than creating a new offence? What would that do? We worked through a whole spectrum of options to get to this point. And then there was the issue of, how do you actually get some of these persistent young people in before the youth court so that the extra tools available in the youth court are there. We've worked through all of those things, but that hasn't been the only thing that we have been doing. We've been doing all of the other stuff around preventing kids from getting onto that pathway in the first place.
How does that sit with you, creating a criminal offence for a 12-year-old?
No one wants to see kids doing this in the first place. My whole focus here, and I know the government's whole focus here, has been about how do we turn these kids' lives around? How do we actually give them a future to look forward to? As I said right at the outset, it's a failing that we've got kids in this situation in the first place. We've got to do more to stop that happening. I'm not going to write these kids off. If they're 12 years old, they've got a whole life ahead of them, and I'm not willing to just give up and say, okay, they're going to spend their life in and out of prison. We can do better than that.
There were much more ram raids, many more ram raids happening in August, September, October last year. Can you confirm whether you pushed for this new offence to be created then, and whether it was addressed by the then leadership at the time?
We've been having conversations right the way through, but as I've indicated, our first port of call was the intervention programs that were designed to stop the offending in the first place. Those programs started to work quite effectively, quite quickly. Over the course of time since we've introduced them, though, it has become clear that there is still a group that we haven't been able to succeed with through those earlier intervention programs, and that's what we're targeting now. As I said, if we had had 100% success with those earlier intervention programs, we wouldn't be here having this conversation, but we haven't, and so hence we need to do more.
Can I just pick up that point as well, is that you rightly said in your question, there were a lot more ram raids in August, October, November of last year. We introduced that raft of those quite, strong interventions, and we've seen the results. But this is the extent. We always said that we'd operate on an evidence base. We have the evidence that shows that, unfortunately, for 100% of those kids, it hasn't worked. But for 77% it has. Yeah. But now we need to make sure that what we're doing now really does address.
You've made a lot about what, how the impact of ram raids happening at the moment, and obviously towards the end of last year as well. Do you think Labor's got the right tone, given that it was only in February when there was an ad published saying that ram raids were down 65%, trying to show off the success there? It doesn't seem like the tones are quite matching up.
No, because I think the message back then was the right one, that we have been, trending ram raids down. The fact is, though, there is still a persistent group who are continuing to offend, so we need to do more. I will absolutely celebrate the success of the programs that have been working for the 3/4 of kids who we are breaking the cycle for. I think we should, because that is evidence that those programs are working. But clearly, they're not working for all of them, and so we need to do more for that cohort.
Has the persistence surprised you, though? I mean, did you anticipate when you put those interventions in at the end of last year and at the start of this year that it would have helped a bigger cohort than it actually has?
Police, in the conversations that I have with them, will always talk about cycles of crime and the fact that you do you do from time to time see peaks of a particular type of offending. They then throw resources at it, and it trends down, and then something will flare up somewhere else. In this particular case, this has gone on longer, I think, than anyone would have expected it to. Okay, look, you get the last question.
Prime Minister, you're balancing two things here, right? On the one hand, you want to stop these children going through the system, getting on the straight and narrow. On the other hand, this particularly the new thing announced today is really for the much tougher end of recidivist offenders, essentially. Now, if you have a dairy or something like that, and you are being ram raided by this, what you characterise as a very small group of repeat offenders, I mean, what is a reasonable expectation for you about how long they are going to be on the street and able to do this for? So once they start in this process, their first or second ram raid, then what sort of time period are we talking about before safety is provided for those communities that are affected?
The ability to ramp through the tiers of responses is pretty swift. So, for example, if the interventions or the intensive interventions simply haven't worked and that young person is caught out, let's say 3 a.m. tomorrow morning after being dealt with already, the police can straight away choose to pursue charging somebody under these provisions.
In a matter of weeks, if there's been a few offences.
Even days. It depends. So that's essentially the optionality that we've provided to decision makers.
But it's important to note that all the way through the system there are opportunities to escalate the response, but there are also opportunities to de-escalate the response as things start to work as well. We don't want to see these kids trapped up in a system because they made a mistake some time ago. Actually, if we can get them back on the straight and narrow, that's the goal we're looking for.
Can I just double check? Definitely offence this time?
Yes, thank you.